Kantarovich here with us today. He's spoken to us, spoken to our group before, twice, I think, right? Once. Oh, it was so good I thought it was twice. And his past lectures, we put them up on our website, and all of our past events are on our website, and this one will be recorded as well, so if you want to pass it on to friends and family and colleagues, please feel free to do so. What we're going to be talking about today is the coming campaign against Israel at the ICC, the International Criminal Court. What can be done, what kind of legal arguments we are to expect from the Palestinians, what Israel's legal defenses are, and how we can orchestrate a counter-lawfare attack. Now, we've seen international courts as one of the favorite mechanisms to delegitimize Israel's lawful acts of self-defense. And we saw it, for example, at the ICJ, the International Court of Justice, where the Palestinians asked for an advisory opinion. And the court ended up proffering an opinion that said that Israel's security barrier, brick and mortar, and a fence in some points, is illegal under international law. And yet the court failed to consider the very relevant point that the fence contributed to a sharp decline in the loss of human lives. It absolutely failed to consider that point, and it also failed to enter into evidence the very relevant testimony of terror victims attesting to that fact. So what we see is a lack of due process, a lack of objectivity, of equal protection under the law. And so the main question is, are we to expect the same thing from the ICC? And what would the benefits and what would the pros and cons be of Israel actually showing up? Because we also know that there's a lot of debate whether or not we should even recognize the jurisdiction of an international criminal court that doesn't have the same type of due process protections that courts have, for example, here in the United States. So without further delay, Professor Eugene Counter-Lawfare.
Thank you for coming this morning. The 9-month scheduled period of negotiations between Israel and the Palestinians, brokered by the United States, is coming to a close in April, with apparently very little to show for it. And in the wake of the inevitable collapse of these negotiations, Israel is being threatened with a tsunami. You might recall that a few years ago, threats were made that if Israel did not accede to Palestinians' diplomatic wishes, it would be assaulted with a diplomatic tsunami at the United Nations, which didn't work out so powerfully. And this is the season of the lawfare tsunami, and that's probably not going to work either, and I predict the next one there's going to be a demographic tsunami. So these are all various threats that if Israel does not sign on the dotted line, it would be there will be these negative repercussions. In particular, the Palestinians' primary threat now is that at the conclusions of the negotiations, they will turn to various international fora, most powerfully the International Criminal Court, and pursue charges against Israeli officials in that forum. What's so scary about this? The threat is that it would vastly delegitimize Israel, the Jewish state, to be hailed into The Hague for war crimes. This would be, whether or not anyone's convicted, it would look very bad and be a further focal point for delegitimization attacks on Israel. So that's the threat, ICC. So there's a few problems that one should note right away about the ICC for jurisdiction. So Israel's not a member of the ICC, and Palestine's not a member either. So those two things together are quite a formidable problem, because the International Criminal Court is not a world court with general jurisdiction over the planet. Rather, it has jurisdiction delegated to it by countries over the countries that join. Israel hasn't joined, like America, by the way, and Palestine has not joined either. So there's a story behind this. Palestine, of course, tried to join a few years ago, and the International Criminal Court responded membership in the court is only open to countries. Palestine doesn't seem to be a country, as far as we can tell, and so we can't accept your application. That is why the Palestinians turned to the General Assembly to be recognized as a state by the General Assembly, which would likely be enough to count as a state for ICC purposes. So again, they can join. But what are they seeking to sue Israel for? What are they threatening to bring Israel to the International Criminal Court for? So it seems most likely, and this is what they principally talk about, that they would bring charges relating to Jewish civilian communities in the West Bank, popularly known as settlements. Why would the Palestinians seek, in particular, settlements-based charges, which aren't what we typically think of as war crimes, nobody's being killed and whatnot? Because if they bring charges relating to the use of force, for example, by Israeli forces, that would also bring with it jurisdiction over what the Israeli forces are responding to, Palestinian terrorism and so forth, because the ICC takes jurisdiction over a whole factual set of circumstances, not just particular crimes. The great thing about settlements from the Palestinian perspective is they're unilateral. That is to say, they're in no danger of being prosecuted in the ICC for their settlement activity, so all of the attention would be focused on Israel. Okay, what is this war crime of settlements? So it's based on the Geneva Convention, which is a treaty about the treatment of civilians in wartime. And there's a provision, Article 49, which is principally about ethnic cleansing, expelling the population of an occupied territory. There's a final sentence in that, which all of the legal arguments about the legality of settlements focus on this sentence. The occupying power shall not deport or transfer parts of its own civilian population into the territory that it occupies. And you can see this is why, by the way, the Jewish civilian communities are called settlements, which is not a word from the Geneva Convention. But it would be awkward and infelicitous to call them deportation or transfer centers, because then people would start asking, how are these people deported? Who transferred them? What did they have to say about it? So that's why they're called settlers, because that's actually descriptive, though it's not a legal term. Now, when they came to drafting the Rome Statute, which is the treaty creating the International Criminal Court and giving all of its jurisdiction, they incorporated word for word all the war crimes of the Geneva Convention. So they wanted to punish war crimes, so they just cut and paste from the Geneva Convention, with one exception. One place out of several dozen they changed, at the urging of the Arab states, who began to worry that deport or transfer does not begin to capture Israeli settlement activity. They added directly or indirectly deport or transfer. So we don't know what that means because it's never been applied anywhere. Well, that's what it says. And this is presumably the substantive provision which the Palestinians would accuse Israeli officials of violating. Again, International Criminal Court is a court of criminal jurisdiction. And they don't have jurisdiction over countries, they have jurisdiction over individuals. Palestinians would presumably accuse or ask for an investigation of particular Israeli officials for participating in this strange crime. Okay. This is seen as a massive threat to Israel, and I want to put it in perspective. People are very worried about the ICC threat. The ICC is, if you don't know, at first glance for sure, a very strange thing for anyone to worry about. This is a court that has been around for 11 years. In those 11 years, it has completed 2 cases, one of which resulted in an acquittal. If you were a U.S. attorney with a clearance rate like that, you would be out of a job. So they're very slow. They haven't done much. And a case like this would be absolutely path-breaking and unprecedented for the ICC. Because the ICC has never taken a case against a non-state party except by Security Council referral, which is a special procedure, not involved here. Has never taken a referral against a non-state party like Israel. And it would be quite a thing if they do. They have never heard a case involving this provision, nor has any court in the history of mankind, in the history of the post-war world. So it would be path-breaking in a number of ways. Nor is it the case that being investigated by the ICC is somehow necessarily a diplomatic kiss of death. Let me mention to you some countries whose activities are being investigated by the ICC. The United Kingdom, the United States. No one knows of this. It's not a big deal. But the activities of NATO countries are under ICC investigation for alleged war crimes in Afghanistan, which is an ICC member. Alleged war crimes. Now, this has not brought America into great disrepute or eliminated America's democratic and international credibility. So it's not really about the fact of an ICC referral. It's not the kiss of death. I'll give you a few other examples of how it's not the kiss of death. Israel itself is already the subject of a preliminary ICC investigation. There's many levels and steps of these investigations that take a long time. In relation to the Maria Marmara flotilla raid, one of the ships in the flotilla was registered in the Comoros. And legally speaking, a ship is part of the territory of a country whose flag it flies. So the attack on that vessel was like an attack on the territory of Comoros, and thus the ICC actually seems to have jurisdiction over it. And the Comoros brought a referral. Actually, a Turkish law firm wrote the referral, and on behalf of Comoros. And the ICC has opened a preliminary investigation. That investigation almost certainly will not go anywhere. The case is not meritorious for a variety of reasons. But it does seem to be at least within the territorial jurisdiction, because there were crimes on the territory of a state, and the ICC is investigating. And that itself does not seem to be a significant diplomatic problem. Indeed, in some cases, political fortunes have been made on ICC indictments. So the Prime Minister and President, or the Deputy Prime Minister and Prime Minister of Kenya, were indicted while campaigning for office. And on the strength of the indictment, they ran on the strength of the indictment and got elected in the process. No countries have broken off diplomatic relations or imposed any kind of sanctions on Kenya because of the fact that their top senior leadership is currently on trial in The Hague and performs some government functions via Skype. So that does not seem to have Kenya. So really, the fear is what the ICC referral would be an occasion for. Like the Goldstone report, the fear is that it would be a signal, a trigger, a starting gun for a further campaign of delegitimization against Israel. Now again, that's not necessary from the fact of an ICC investigation, witness the investigations of the United States and its NATO allies, but it could well be used as such. That's a big part of the concern. Okay. As it happens, assuming that Palestine is a state for purposes of ICC jurisdiction, as it happens, it seems quite clear that the relevant crimes do not fall within the jurisdiction of the court. The court's jurisdiction over non-member states, like Israel, over the nationals of non-member states, has to be based on activity that occurred on the territory of a member state. So it would have to be that it occurred on the territory of Palestine. Now, however, just because Palestine is a state, let's say, for ICC purposes, from that it does not follow that the settlements, in particular, are on Palestinian territory. Because there's actually two distinct questions. Is Palestine a state? The ICC says, we don't decide those kind of things, we'll leave it to the General Assembly. But then an entirely separate question is, what are the borders of that state? What are the borders of that state? And those borders seem substantially disputed and undefined. The General Assembly resolution, recognizing Palestine as a state, did not prescribe any borders, and indeed called for the establishment of borders in the future through negotiations, thus suggesting borders are not currently established. Well, why don't we just say it's the 1949 armistice lines, the so-called 67 borders? So, there's two problems with the so-called 67 borders, very inaccurately named. First of all, they arise from 1949, the 1949 armistice lines, and the armistice lines themselves describe themselves as not being an international border. So, other than that, the 67 border is a pretty good description, but it's not 67, it's not a border, and indeed, subsequent international practice confirms that it's not an international boundary. For example, the peace treaties between Israel and Egypt and Israel and Jordan in 1980 with Egypt and or 79 and 1994 with Jordan specifically refer to the mandatory border of Palestine as the international border. So it's not a recognized boundary. And then it also leaves a lot to, it doesn't really work well as a boundary. It doesn't really work well as a boundary. Why not? So it turns out that there's really no single green line. In many places there's several green lines, because again this was an armistice agreement, and it created a variety of DMZs, various kinds of no man's lands, and much of the most disputed settlement building is actually in those territories. So what country would that possibly be in? What country would that possibly be in? And finally, probably most important, the Oslo Accords specifically exclude Palestinian criminal jurisdiction from all of the area of the settlements. It limits Palestinian criminal jurisdiction to area A and B, where 0% of the settlements are. The ICC works on a system of delegated jurisdiction. Delegated jurisdiction. A country has criminal jurisdiction, and then it gives some of it to the ICC. One obviously cannot delegate that which one does not have or has already elsewhere delegated. More importantly, the Oslo Accords show that there's really no reason to believe that the 49 armistice lines are the default boundaries of the Palestinian state, because they create quite different boundaries entirely. And of course, all of the settlements are within the Israeli-controlled territory. The most fundamental point is this. There is a strong argument that the Geneva Convention does not apply to Israeli settlements at all, does not apply to the case of Israel. Why? Why? Because it says, because the Geneva Convention specifically applies in cases of the occupation of the territory of another Geneva Convention signatory. It's a treaty, it's a deal between countries. So the Geneva Convention rules about occupation, of which Article 49 is part, apply in cases of the occupation of the territory of another Geneva Convention member. It's quite clear that the West Bank was not the territory of Jordan in 1967. So why does the Geneva Convention apply? The answer of international lawyers is, look, the Geneva Convention is like, it's not just a treaty, it's a good idea, and we want to apply these rules broadly because they're good rules and we should not have gaps in their application, so it applies to any occupation of territory. So the mere fact that people think that Israeli settlements fall under the Geneva Convention does not depend on them being in the territory of another country. And indeed, international lawyers, in arguing that the Geneva Conventions apply, have specifically said, even though it's not in the territory of another country, Palestine, they still violate the Geneva Conventions. So the point is, you can violate the Geneva Conventions but not fall within the jurisdiction of the ICC, because that requires it specifically to be on the territory of a member state. That territory has not yet been established. Now, if the ICC were to overlook this, were to play fast and loose with the territoriality requirement, it would open up a massive can of worms whose reverberations would go around the world. So, most important, this is not the only place where there's a territorial dispute. Not the only place in the world where there's a territorial dispute. For example, South Korea is a member of the ICC. North Korea is not. They have a territorial dispute which is the size of the Korean peninsula. Does this give the ICC authority to determine who owns the Korean Peninsula, as between the two countries. Most importantly, let me take a step back, mention a broader principle. I mentioned the ICC is a court of international criminal jurisdiction, correct? What it does not have is power to demarcate and determine international boundaries. What court would do that? The International Court of Justice is in the business of boundary disputes. But it can only do that under one circumstance: when all of the relevant countries agree. When all of the relevant countries agree. And then it has jurisdiction to determine their boundaries. No one has ever suggested that the ICC, which only has jurisdiction over individual criminal defendants, can demarcate boundaries, and what would be a complete novelty for international law, demarcate the boundaries of non-consenting countries. There's a notion in international law called the monetary gold principle, which says that a court cannot decide a case involving international rights unless all of the parties, all of the countries who are involved, are a party to this case. Determining the application of this provision necessarily involves determining the territory of both Palestine and Israel, which is not a party. No one will ever have to get consent from another country, from an opposing country, to go to the ICJ anymore, because you can have territorial disputes adjudicated without the other side's consent in the ICC by just claiming the action occurred on the territory of your state. Should be of particular concern to the United States. Let's say Cuba accepts the jurisdiction of the International Criminal Court today. Does that jurisdiction extend to Guantanamo Bay? Well, it's not really part of Cuba. The Supreme Court held that the United States acts as a sovereign authority there in the Guantanamo cases. Okay, but it's under a lease agreement, so maybe it really is part of the territory. And Cuba can pursue ICC cases against America for activities in that territory. And maybe yes, maybe no. But if the court takes this case, it would mean that America would not have to willingly agree to ICC jurisdiction. The ICC would be empowered, purely by virtue of its criminal jurisdiction, to rule on the status of Guantanamo Bay. That's just one example of how this could be extremely dangerous for the United States. Moreover, it would allow the ICC to have jurisdiction merely by, in effect, a majority vote of the General Assembly, because that's all it takes to be recognized as a state. Let's say that the United States troops are fighting somewhere in a globally unpopular war in a country which is not a member of the ICC. So the United States thinks it's low risk. No, I see, low lawfare risk. And then one of the groups in this conflict says, let's go and get ourselves declared a state at the General Assembly. It doesn't take much, it just takes a majority vote. Then you could join the ICC and all of a sudden subject the United States to jurisdiction in a situation where it seemed previously entirely unlikely. And indeed this is already happening. This is not a situation where the United States is currently involved, but the Sahrawi Liberation Front, the Polisario movement in Western Sahara, as soon as the Palestinians got their resolution passed, they said, hey, this is fantastic. If all you need to join the ICC is a majority vote at the General Assembly, we should have a go too. So this would be extremely, extremely destabilizing. Okay, so this is not on the territory of Palestine. That's a big and fairly bright line limitation on the court's jurisdiction. Okay. According to the preamble of the ICC, I mentioned the ICC has only heard 2 cases. Now, it's investigating more, maybe a dozen cases. But the notion of the ICC was never that it would have a very heavy docket. It's done less than expected, but by its preamble makes clear that it's supposed to only deal with the gravest crimes of international concern, the most atrocious. That is to say, the ICC was created, war crimes are one thing within its jurisdiction, other things are genocide, crimes against humanity. The ICC was created specifically to deal with the most atrocious crimes that shock the conscience of mankind, Rwandan genocide, Yugoslav genocide. Because of course, ordinary war crimes are a dime a dozen. Every armed force inevitably commits them in every armed conflict. And the goal of the ICC was not to prosecute all otherwise unprosecuted war crimes, but rather to deal with the biggest things. And that is reflected in a jurisdictional criteria called gravity. Crimes have to be... Now, this seems at first tautological, because the ICC only has jurisdiction over genocide, crimes against humanity, war crimes, aggression. So what's it mean? Aren't those things of sufficient gravity? No. Specifications of genocide, specifications, particular acts of crimes of humanity and war crimes that are themselves. So the worst of the genocides, the worst of the war crimes, the worst, or certainly not the least of the genocides. Certainly. Now, no one knows what the word gravity means. That is to say, they never told us how to figure out what is and is not of sufficient gravity. It remains undetermined. Again, there hasn't been a lot of case law. But the prosecutor has developed the following criteria. So the first thing the prosecutor looks at is how many people have been killed. Because there's lots of bad things going on around the world. People get killed in a variety of situations. If too few people are killed, the prosecutor has said, it does not warrant ICC intervention. So, for example, in a case against British special forces for killing some Iraqis, there was 6 or a dozen Iraqis killed, but not enough dead people. Not enough dead. So how many dead people are involved in the alleged crimes here? So 0 dead people. Okay. Next factor. So you don't just need dead people. There's, for example, crimes like mass rape and child soldiers. So in those crimes, which don't involve killing anyone, absolute number of victims for violent, forcible crimes. By the very definition of this provision, there are no victims. It's one of the unusual Geneva. It's unique almost in the Geneva Conventions, in that it is a victimless offense. It is not something that is done to people. And some international courts have actually noted this, that unlike killing civilians, plunder of property, this is not something that's actually done to anyone. It just occurs in a place. It might affect the interests of a population, but it does not have any individual victims, and the ICC's rules about victims actually say that victims have to be individuals rather than populations. So in terms of number of victims, again, we seem to be at 0. We seem to be at 0. There's also an implicit hierarchy of crimes in international law. It's not written down anywhere, but it's reflected in sentencing decisions of international courts. And it basically goes, genocide is the worst, crimes against humanity is a little bit less, and war crimes is less. So this is already at the bottom. It involves nobody getting hurt, no forcible action taken against anyone. And indeed, if I were a lawyer, I would say the first place to start figuring out what gravity means is the use of gravity elsewhere in the same treaty. The only other substantive use of the word gravity is to distinguish between 2 kinds of war crimes, so-called grave breaches and non-grave breaches. The alleged crimes are themselves non-grave breaches. So indeed, they seem to be the least grave offenses that you could imagine. Okay. But still, there is some population interests at stake. What are the population interests? The nature of the protected. So the norm against transfer is, according to the ICRC, supposed to protect the local population, not individuals, but the population as a whole, against 2 kinds of injuries. An economic injury, being deprived of their livelihood, because again, the way it used to work is this: Article Clause 6 violations happen along with Clause 1 violations. You kick out the people who are there, and then you move in new people. That's why they're part of the same overall provision, because this usually works better after you've done that. The moving in is usually helps. It helps to move people out first. So economic injury. What's been the economic injury of Palestine? The economic growth in the West Bank has obviously outpaced those of all neighboring Arab countries, and certainly its previous growth. The other thing that, according to the Red Cross, this provision is supposed to protect against is, and this is, we don't use these kind of words anymore, but this is what they say, the Red Cross, to protect the existence of the population as a separate race. Now, I don't know what that means, but the Palestinians seem to be rather flourishing as a separate race since 1967, when nobody thought of them as a separate race, to now, when they are universally acknowledged as such. And indeed, Israel is being threatened with a demographic tsunami if it does not leave these territories, because the Palestinians as a separate race, apparently, are very successful. And their separate existence as a race is actually said to threaten the separate Jewish existence as a race. So both things can't be true, obviously. But so it does not seem that those concerns are involved. So again, it does not seem to satisfy gravity by the terms of the interests it's supposed to protect, by the hierarchy of crimes in the statute, and by the more objective factors of violence and number of victims. Now, again, this should be of extreme concern to the United States, because the United States is involved in many activities which can be colorably labeled war crimes. I'm not saying they are, just like I'm not saying the settlements are war crimes, but which much of the international community thinks are war crimes, in particular drone attacks. So it doesn't make as much news as the building of a house in eastern Jerusalem by Jews, but there are occasional Afghan wedding parties, Pakistani villages that are taken out by NATO missiles. And if building a house, now the United States again is not party to the ICC, but it can act maybe in territory of a country that does accept ICC jurisdiction. And currently the thinking is amongst American defense officials, we don't have to worry about this thing because it falls under the radar of the ICC. It doesn't add up to enough. A wedding party here, a village there, but like in the end, you don't really have a critical mass for gravity. But if the building of a few houses, even building of a lot of houses, satisfies gravity, surely the destruction of a village would satisfy gravity. So the United States should be extremely concerned about the setting of a low threshold for gravity. And I would argue that if these crimes would satisfy gravity, it would be hard to think of crimes that do not satisfy gravity. Now, one might say the following. Haven't I effectively read the deportation or transfer crime out of the treaty? That is to say, if this doesn't satisfy gravity, how could it ever satisfy gravity? I would suggest a few answers to this. First of all, it's not a coincidence. It is not a coincidence that Article 49.6 in the Geneva Convention accompanies Article 49. That is to say, in most cases of settlement activity around the world, it is preceded by the expulsion of the local population. Really makes things easier. So, as we're about to see, to accomplish those kind of goals. So, the ICC takes jurisdiction based on the gravity of the entire situation, not just the gravity of a particular crime. The Palestinians, unusually, in the history of these kind of things, don't have a 49.1 violation to point to. It's a freestanding 49.6 claim. However, in many other cases, such as Turkey and Northern Cyprus, Syria and Lebanon, Russia and Georgia, Armenia and Azerbaijan, China and Tibet, in many contexts in which this kind of activity happens, there's a 49.1 violation that would accompany it and which would satisfy the gravity criteria. So remember, there's jurisdiction and then there's particular crimes. So I think the most common situation would be that the court would have jurisdiction of a 49.6 offense when it's parasitic on some other, when it's accompanied by other offenses that independently satisfy gravity. Is that anomalous? Is that some strange thing I invented? It's actually what people say about another crime that is of interest to Israel. The ICC charter makes it a crime to commit genocide. One of the ways in which, one of the definitions, one of the specifications of genocide is incitement to genocide. That is an independent count of genocide, incitement to genocide. But then we have a puzzle. We have some well-known people who incite genocide. Why doesn't anyone make an international case out of this? Take, for example, Iran. Indeed, if Palestine were thought to be a country within the jurisdiction of the ICC, and the settlements are in Palestine, then surely the genocidal cause of the Iranian government, which must be targeted to the Jews in the West Bank as much as the Jews on the other side of the Green Line, would then fall within the jurisdiction of the ICC by virtue of Palestinian territorial jurisdiction. But this is what people say about this. They say, look, incitement, it's a little weird. What they really mean is, what it really means is incitement by itself, it doesn't seem to be of sufficient gravity. But wait, isn't it incitement to genocide? Only if they actually succeed. So if the incitement is actually accompanied by an actual genocide, then the genocide satisfies gravity, and then incitement is another separate crime that you can prosecute the inciters for. And indeed, there have been prosecutions for incitement to genocide in Rwanda and elsewhere, but it was only in the context where the genocide actually did ensue. It doesn't have to be causally related to the incitement, but just without an actual genocide, why bother? We can't just prosecute every person who says some crazy stuff. So, very same logic, that it's parasitic on gravity being satisfied by another crime. Now, in any case, I think it is potentially, it is possible that one can imagine a freestanding violation of this provision that would satisfy the gravity criteria, because it would, for example, significantly undermine the underlying protected interest. What would that look like? Well, I mean, so what does it mean to threaten the existence of the protected population as a separate race? Again, I don't know what it means. People try not to remember that that's what it says, because it doesn't sound good anymore. But I think what it means is create some kind of strong demographic problem for them. What would that look like? Let's say if the transplanted settler population becomes a majority in the occupied territory. Well, that is the case in northern Cyprus. These are, by the way, a bunch of other occupations that involve settlers. And this is a research project I have been undertaking to look at how settlements are treated elsewhere in the world on a variety of axes. A project which I began with the help of my brilliant and gifted student, Dana Bruska, who is right here. Hi, Dana. And she helped me a lot on this project. So Turkey occupies northern Cyprus, which is an independent country, part of Cyprus. It seems that the majority of the population of northern Cyprus are now Turkish settlers. Now, we don't know precisely, because, as I like to say, where is peace now when you need them? So they're not flying over and photographing every Turkish house and counting the Turks and making, they're not sitting at the port in Ankara seeing how many people get on the boat for Cyprus. It's a shame. I would actually like peace now to be active in this area, because Dana and I have had a hard time figuring things out here. Western Sahara, quite clear that the majority, the significant majority probably now, are Moroccan settlers. Again, we don't really know how many, but maybe one day Peace Now will tell us. Now, Western Sahara is not of immediate interest. Cyprus is of immediate interest. What makes Cyprus special? It's a member of the International Criminal Court. So Turkish settlements in Cyprus are clearly within the territorial and temporal jurisdiction of the International Criminal Court. Nobody has ever suggested, though I and some people I'm working with are about to suggest, nobody has ever suggested that those settlements create a war crime within the jurisdiction of the International Criminal Court, which makes it very hard to argue that Israel does too. In anticipation of a potential referral involving Israel, it is useful to keep in mind the situation, the ongoing situation in northern Cyprus, and to have people be aware of this. It is a particularly galling irony that Mahmoud Abbas announced, one of many announcements actually, one of the many times he announced his intent to press a case in the ICC against Israeli settlement activity, was standing next to the Turkish president at a press conference in Ankara. So obviously the notion is that this is a rule which only works one way. By the way, the ICC, as you know, it used to be Dana and I were the only people in the world who cared about this, but Russia did invade Georgia and occupy parts of it. And there has been, it's very hard to document, but there has been Russian settlement activity in occupied Abkhazia, which now people may have heard of. Before, when I used to say that, people didn't believe me that there was such a place. I'm making it up. So occupied Abkhazia has Russian settlers in it. The ICC is very slowly, you've never seen anyone do anything this so slowly, investigating a case involving Russia and potential Russian war crimes in Georgia. Violations of the anti-settlement norm are not amongst the crimes they are investigating, which presumably means the prosecutor does not think there is any basis to consider the movement of non-Georgians into the territory as a violation of the relevant norms. Will all of this make a difference for Israel? I don't know. I would like to say that the ICC referral, it's not a trivial matter. It is something to worry about. It is definitely a threat, and it is definitely a problem. But it's not the end of the world. It is not something for which Israel does not have arguments. The basic argument, and again I say this as a lawyer, is there's no jurisdiction. There's no jurisdiction. There's no jurisdiction territorially, temporally, from the perspective of gravity. Of course, as an entirely separate matter, Israel would insist, I think correctly, that it is not in violation of the underlying substantive norms, that has not committed a crime. But more importantly, the court, ICC is a court of limited jurisdiction. Israel is not a member. The territory on which these crimes are, alleged crimes are occurring, is not the territory of an ICC member. And if the ICC were to proceed in such a case, and this is what I think as Americans we need to focus on and keep in mind, it would be a massive liability and risk for the United States, which would be a matter of concern for Congress, should be a matter of concern for those who care about the United States military. The United States currently thinks that it does not need to worry about the ICC because it didn't join. It was worried about the ICC. There were concerns. Senators didn't want to proceed with the treaty. And so the United States is outside of the ICC. Being outside of the ICC would be a very thin defense to ICC proceedings if such a case were allowed to proceed. And that's why this is a matter of national concern to the United States as well as to Israel. Thank you very much. I'll take questions.
Yeah. Okay, I'll start. So let's say this does go to the ICC. Would you advise that Israel represent itself and present those arguments, or do you think that Israel should boycott the court and have people like you write amicus briefs? How could we procedurally go about
I think
defense?
Israel needs to present these arguments. Someone is initiating a proceeding where you believe there is no jurisdiction. Argue that there's no jurisdiction. Israel did not participate in the ICJ case concerning it, because Israel refused to accept the jurisdiction of the court, at which point there is no jurisdiction. It was argued that even though there's no jurisdiction, Israel should participate, to which Israel said, no, that defeats the point of there not being jurisdiction. That is to say, we have not given the court authority to adjudicate this dispute, and so thus we don't think it should be adjudicated there. So this is different because and Israel did argue the jurisdictional issues, and Israel should for sure argue the jurisdictional issues there. Israel, I think, should do more and explain to the countries like the United States that are not part of the ICC, countries like India, the dangers that such a proceeding would bring. I think it should explain very clearly to Turkey and Russia the dangers to them of such a proceeding. And indeed, Israel, they're used to getting kicked around, so they're not very good at being aggressive. But I think it would help a great deal if Israel itself were to begin making threats, such as if the court accepts Palestine as a member within the full territory of the 1949 armistice lines, then there's zero cost to us, Israel, joining the ICC and immediately bringing a referral against Turkey for settlement activity in northern Cyprus and Russia for settlement activity in Abkhazia, which would be the end of the ICC. That's it. They'd blow it up.
But would Israel have standing to do that?
Oh
Is
yes,
there a
that's the
concept
thing.
of standing?
That's the thing. Once you're a member, any member state, it's not that referring a situation within the territory of an ICC member can be done not just by that ICC member, but by any other ICC member, and those cases go to the head of the line. There's other ways. Anyone could actually, any NGO, for example, could write a referral about the Cyprus situation. Interestingly, Amnesty and Human Rights Watch have not done so, but basically, in terms of how the prosecutor goes through his docket, NGO and other type of referrals, which are called complaints, they go to the bottom of the pile, but he's basically forced to investigate, open investigations in cases referred by other countries. That's why the Comoros referral is going to the head of the line, even though it's quite clear the prosecutor's not interested in it because it was referred by another country. Yeah.
So, given all the issues that you spoke about, assuming that the Palestinians know what Israel's argument's going to be, saying that there's no jurisdiction, why do you believe that the Palestinians are still pursuing this? Do you think that they're just rabble-rousing? Like, what can you speak to?
Well, so they have their argument is, look, everybody knows. They're going for the popularity contest argument. Everybody knows that the borders of Palestine are the 67 borders, and there's 100 times that the EU has said so. Now, again, interestingly, the relevant international documents, the ICJ advisory opinion about the wall, the General Assembly resolution, they don't actually say anything about exactly what Palestinian territory is, and they make it clear that the borders need to be determined in the future. But they'll say, look, you know what it is. Everybody knows. It's not such a leap. This is what everybody thinks the Palestinian border should be, so just say it. And that they have a good chance that maybe that is indeed what the court will do. I mean, again, just because the court doesn't have jurisdiction doesn't mean they won't find jurisdiction.
So they're just trying to bring the spotlight back onto defining the borders.
Well, yeah, it could get them the borders adjudicated in the ICJ, in the ICC. That would be fantastic. And they have relatively little to lose. The risk is all on Israel, which is another reason Israel needs to start explaining to the world how there are broader risks involved here.
Two related questions. First of all, would a defense also be that many of these settlements were already constructed prior to Palestinian being named as an observer state at the General Assembly, which is the basis for its assertion of state status? And secondly, just to be devil's advocate, could the Palestinians argue that not just the building of the settlements, but their displacements, they'll argue destruction of their farmlands, the checkpoints, the whole collection of activities around the building and securing of the settlements and the adverse impact on the Palestinian residents. Could they make that kind of an argument and get to the gravity threshold?
So it's related, those questions. The jurisdiction of the court is explicitly only prospective. Now, there's a question, prospective from what? It would seem, by, I think, a natural reading of the relevant instruments, prospective from when they accept jurisdiction of the court. So once the Palestinians accept the jurisdiction of the court, which they have not yet done, they're threatening to do, the clock would start ticking from there. Other people want to say that now that they're talking about Israel, want to argue that it could be done retrospectively. This has never happened. That would be a massive danger for the United States. But it would still seem, even if it could be retrospective, it would have to be retrospective at least to no further than the General Assembly resolution. So that limits the amount of conduct in question, and I think that further cabins the gravity. As for adverse eminent domain of Palestinian lands and whatnot, for the building of settlements, almost all settlements were built on state land. However, to the extent some property was was subject to eminent domain, again, all of that happened in the 70s and would fall outside of the temporal jurisdiction of the court. Things like checkpoints are not a war crime. I mean, what's great about them is that there's a provision in the for the about the settlement issue, is that they wrote the relevant provision to target Israel with the indirect transfer. So that's a gold mine. That's why Israel didn't join. So again, I think temporal jurisdiction also limits the gravity. But again, there's academic theories that have been generated once the Palestinians started seeking this jurisdiction, that maybe you can actually have retrospective jurisdiction. No one had previously thought this, but now there are some theories to this effect. And so the question is, when do you cross the threshold? When do you cross the threshold? Turks have been at it for quite a while, and Cyprus has been a member since 2002. So all of the Turkish settlers for the past 12 years would count towards the gravity threshold. Apparently it has still not been met.
Well, the adverse impact argument would be, I think, that the checkpoints, some current evictions like in East Jerusalem, destruction of farmland, all of that is ancillary to the transfer program.
It would still have to be a war crime.
But it's the argument would be it's supporting the quote war crime, helping to make the transfer successful.
I don't think that would be the best argument. Again, the evictions in East Jerusalem are of people who are living in someone else's house. So the typical situation in East Jerusalem is there's a house that belongs to Jews that they've owned for a long time, and they're trying to evict the Palestinian tenants, and eventually they get around to it, and it's a big international incident.
Okay.
There are 2 checkpoints in the entire West Bank, so I just don't think that would be vastly helpful, and there's nothing in international law. In the law, occupying power is allowed to have checkpoints. This provision is one that was tailored to Israel, and that is why it is useful for them. Otherwise, the occupying power is allowed to evict people who are squatting in someone else's house. The occupying power is allowed to have checkpoints for security purposes, and so forth. Brooke.
Okay. I have lots of questions, so in between when you guys put your hands up, I'm going to ask them. So a couple things. Instead of using the term settlements, what do you recommend to use? Instead of using the term occupying power, I don't know if you disagree with that, what should we use? And what do you say to those who argue that Israel is indeed indirectly transferring its population by offering it a certain amount of benefits, by providing a road system, by providing electricity, they're making it possible for people to go there, and therefore that's indirect transfer. How do you argue against that?
What was the first question?
So in the terms settlements, the terms occupying power, do you agree using them? If not, what are alternative terms? And then how do you argue against those who say that Israel is indirectly transferring by encouraging people to move there somehow?
Yeah, I have a lot of mixed feelings about the whole word issue. Some people want to attach great significance to what you call things, and I understand that what you call things matters and shapes ideas. On the other hand, if you're trying to speak to people who do not already share your views, speaking a common language, and then explaining why, even on their own terms, it does not have the consequences that they think, could also be useful. I don't think under international law Israel is an occupying power because I don't think the Geneva Convention applies. If I speak of it as such in the current context, it's because I'm doing the very lawyerly thing of assuming in a jurisdictional discussion that the arguments on the merits are valid. I actually love the word settlement because it is so clearly absent. The word settlement and settling is so clearly absent from the relevant international legal instruments, and it only highlights how far it is from deportation or transfer. So, building roads, the occupying power has an obligation to provide basic services for whoever happens to be in the occupied territory. So if Jews go to the occupied territory, they can make roads for Jews. Now, does that make it easier for the Jews to go? Sure, but nothing here says that it has to make... So the way the world wants to read this provision is the transfer directly or indirectly, blah, 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 is illegal. And they also need to stop people from going themselves and make it hard for them to go and penalize them from going and fish them out. So again, indirectly, whatever indirectly means, you still need an act of transfer. And transfer is some kind of organized movement of people. So what if there is, again, it's important to understand, Israel has done itself a massive disservice by creating the following baseline. So, if you're Morocco, my understanding is any Moroccan who wants to can go to Western Sahara. Mazel tov, thank you very much, thanks for helping. If you were Syria during the Syrian occupation of Lebanon, any Syrian who wanted to go to Lebanon could, and indeed most did. They had a massive Syrian population. Armenia, they love it when someone goes to the occupied areas of Azerbaijan because nobody wants to live there, and they're very excited about that. So, and the same with Russia and Georgia in all these cases. Israel, it's a little bit different, because Israel is the only occupying power on this list that I know, or allegedly occupying power, that actually, from the beginning, has been trying to give away parts of the relevant territory. But from 1967, it has been the fondest dream of every Israeli government to find someone to turn over at least some part of this territory to, and have a peace treaty and say goodbye. That is why Israel has not annexed the West Bank. Morocco has annexed Western Sahara because their position, we're never giving this up. No, we don't want peace negotiations, we don't want a treaty, we're done. What's there to talk about? So, to make it easier to potentially give it up, the baseline law implemented by Israel is you can't just move into this territory. In other words, as a discretionary act, Israel chose a much stricter regime than required by the Geneva Convention. So you can't just move in to eastern Jerusalem, into Hebron. You can't just go to a hill in Gush Etzion and start building. Not because of the Geneva Convention, because the Israeli government says we want to limit that kind of thing. On the other hand, they don't feel that they should entirely stop it and keep the area as a Jew-free zone for 45 years. So they say sometimes we will allow it. Sometimes we will allow it. But because of the change of baselines, it then looks very bad in the news. When it says, Israeli government authorizing the construction, or Israeli government promotes settlement. What's promote settlement? It means we're suspending the normal rule of you're not allowed to go, and now saying, you few guys, you can build some houses. But in any case, if you're to try to take any nuanced view of what transfer means, and try to do the very Jewish thing and say everything is gray, and maybe we're a little wrong, maybe we're a little right, you'll find no support in the international community for this. Because let's say that building a road is okay. Because I could still give you a bunch of examples of things that would for sure not count. So for example, let's say some Jews, without the knowledge of the government, this is a real story, it just happened, without the knowledge of the government, buy a house in Hebron from its Arab owner and move in. The government hasn't done anything to indirectly transfer them or directly, because the government didn't know this was happening until they move in and have a press conference and everyone in the government saying, oy vey. Okay. So, no matter what you think indirect means, that would seem to not count. Or, for example, somebody has a baby. That's it, there's just a baby. That would seem to not count as a transfer, that is a delivery. I know of no international legal authority who would say that those cases are not also included. Indeed, the settlers who buy a house in Hebron, they're the worst settlers. They're the worst. I mean, they bought a house. That's even more dangerous because it's very hard for the government to prevent. But if you're building new things, the government can see, and they can have zoning rules, and they can say, it's, we're not going to allow this zoning, but it's very hard to just say we're not going to allow private contracts. It's Shelley versus Kramer. It's restrictive covenants. How are you going to, it's very hard to enforce. So that's why those are seen as the scariest settlers. Because you can't keep them out, they just buy it without anyone knowing, except for the seller, who's obviously a willing participant.
And then they have 10 kids.
And then they have 10 kids. So now, what if you say, well, what's the international, what's the other side say about this? What they say, I think it's, you're only going to believe it if you're prepared to believe it, is that no Palestinian would willingly sell a house to a Jew. Because that's a very bad thing to do, and the only reason they do it is because of their powerlessness of their bargaining position under the occupation. It's amazing that Palestinians sell houses to Jews because it's, of course, punishable by death under Palestinian law. which was not something that's a result of the occupation, but is rather a continuation of the previous Jordanian rule, which is a continuation of the previous Turkish rule, barring sales to Jews. So Israel clearly goes about this all the wrong way. Every decision to allow someone to build a house happens in 20 steps with 20 bureaucratic announcements. That makes it look, people think they built 20 houses. 20 announcements to build one house. All of this is a big disaster. But this is a country whose foreign ministry is on strike right now. So what can you expect from the clever management of the situation? In the backside.
Do the Oslo Accords and the delineation of areas A, B, and C in the territories have any impact